Good afternoon, everyone, and welcome to the ninth talk in the Only One Team talk series. We are at the second wave now, and this is the ninth talk in the second wave. This series is being hosted by the TechX.in vertical at Venture Center. The entire series is focused on innovation management, and today's talk is focused around anatomy of an investment agreement. Our speaker for today is Mr. Vivek Sadhale. So, welcome Vivek to the session, and I'm going to introduce you briefly. Vivek works as a founder partner at LegaLogic Law Firm with over 24 years of experience. He has expertise in international technology and commercial contracts, navigating the complexities of global business transactions. He has demonstrated a track record of success in guiding organizations through the intricate process of initial public offerings. Specialization in top tier venture capital investment and private equity funding. Proficient in mergers and acquisitions, joint venture agreements, and managing investor relations. Worked with reputed Indian and multinational organizations with exposure to finance and treasury functions. So, Vivek, with this brief introduction, welcoming you to the session and handing over the session to you.
I'm sorry, I was talking on mute. Okay, hi, good
Oh,
evening,
yeah.
everyone. Thank you, Mugdha, for the introduction and invitation. It's always a pleasure to be on the Venture Center platform. They are doing a great job, and every time I'm on this platform, feel energized. So thank you, Mugdha, one more time. I'm going to share my screen, and let me know if you can see it. This is just a presentation. Today we are on a online mode, and this is a bit tricky in terms of me understanding if you are all understanding the talk or not. But nonetheless, the chat box is open, and at appropriate time, Mukta, you and someone from your team can interject and stop me, because this whole idea is to see if I can communicate with the participant, and if they can benefit from the next 55 minutes that we have together. Uh, as Mugdha said, we run a law firm, and that allows us to have audience with a lot of investors and lot of companies seeking investment, and we deal with this on a very regular basis. And that is one of the reasons why I am here today to speak about some of the nuances on the investment agreement. While I do so, I also want to take you through certain important things that lead to an agreement. Agreement, as you would know, is a reflection of the thought process that gets built over a period of time. And that's an important way in which we should all look at how we evaluate, the investment agreements. It can't be looked in one fit cut all situation or in a static manner. It has to be looked upon in a holistic manner. And that's what I'm going to talk about. Just as a reference point, we started almost 10 years back, and the startup was not the word spoken in 2013 as effectively as it is today. Obviously, today it's no more a taboo. There is no more situation where someone actually earns a brownie point when he is talking about a startup. And we have come a long way in a short decade time. And this looks like this will continue unabated for a long period of time. And this is all here to stay in India for sure, cross border for sure. And we will all have a huge opportunity at some point in time or the other to either be participating in negotiating investment agreement on one side of the table or the other side of the table. So this is as exciting as it is, and we do this for a living, and I can only tell you that it can get better as you get deeper into it. And there's no better way of looking at how you actually close a transaction. How do you see your client, get money in the bank, investors making money, and overall, the economy booming. That's what the excitement is about. And today I'm going to focus on these issues, which is what is an investment process that leads to the clauses that get negotiated, what are the management considerations, and what are the governance and oversight situation that we need to be uh, uh, in know of, what happens at the time of exit. I'm going to talk a full cycle, time permitting, and feel free to put your questions in the chat box. When you think that I'm using jargons and those are not clear to you, or I'm going fast, then the pace at which you think we should talk, or anything that is not helping you to understand what I'm trying to understand. My objective here is to make it as lucid and simple as possible for you to reflect on this whole thing. And then maybe you will have more intelligent questions coming to your mind that you can ask today or at a later point in time. My email is, part of this presentation. As you can see this, happy to answer questions that time doesn't allow. Obviously, as I mentioned to you, we do this for a living, and 1 hour is not a great time for me to completely deep dive and give you a full flavor. But the whole idea here also is not to get an expert knowledge, but to provide you with the basics and also to introduce you to this topic for you to ask right set of questions to experts, so that as you seek investment or as you invest, either ways, you are fully in the know of what you are getting into, because this is hard earned money and that has to be all protected. Or you're investing time to make money for someone who's invested in you, and you in turn are making money. So it's a fascinating sort of overall journey in the investment process, and that's what I'm going to talk about. There are two types of players that you look at. One is private equity, and second is venture capital. And I'm keeping my conversation on the equity side of the fundraise and not on the debt side. I'm not talking about the investment agreements which are, related to loan. I'm concentrating on shared capital. It could take place as equity or preference or what have you. I'm concentrating on that aspect of it. And then you have two major buckets in which it could fall. One, where we say it is a PE, which is private equity, or the other is VC, which is venture capital. And then the subtle difference and the major difference between a private equity and venture capital is that venture capital come in early. The stage at which they come in is fairly early, and therefore they take a lot more risk than the private equity folks. Private equity follow venture capital and not the vice versa, which means that the company who's venture funded, as they call that, would graduate to a private equity, which is a larger fund, and they take bets on a growth story, but a matured growth story. We are talking about something where the growth is something which both want, but at what stage of growth will venture capital come and private equity come differs. And as I said, private equity follows venture capital in that way. Private equity usually likes a bigger chunk of the company as against the venture capital. Venture capital would look at a dollar amount as to how much they are investing and how much risk on the money that they're willing to take. The percentage of equity is resultant of that, whereas the private equity is more to do with the fact that they would invest a larger sum of money and take a larger pie of the company. Many a times, the majority capital is owned by private equity, and therefore the amounts are larger in private equity play as against the venture capital investment. Uh, let's see. And once you decide whether at what stage of the company's journey are you in, and whether to go with a VC or a PE. PE is of course late stage, may not be relevant for many of you at this point in time, but for those who have a matured play, then obviously private equity comes into play. Before this, there is what we call as friends and family, or individual investor, HNI investment, that also is prevalent. Though, again, my conversation is restricted or is typically uh, from an institutional investment standpoint and how those matured agreements are in that way. So let's go to what is the investment process. That investment process is a total movie in the mind in terms of how a investor and how a investee looks at the whole thing at that time. So let's look at what is this about. One is to identify what are the goals of the parties. Very, very important. And this looks like a motherhood statement, but a mismatch on the goals and the objectives could derail overall, the job that you all both are set up for. That goal setting is a very critical thing. And then, are there alternatives to achieve your primary goal? Which means that is equity share investment possible? Is a preference share investment possible? And what all can we think about which satisfies most of the primary objectives? That's something which is very, very important. And then, are you ready to share the risk? Any investment, both for the investor and the investee, is a risk. But how do you actually measure that, and how do you share those risks will determine how you would effectively function as you go forward, because this is an important and a critical uh, uh, situation for both parties to look at. How can you share the risk? Please understand that this is always between the principal to principal. It is about investee and the investor. At some point in time, it is about regulators, it is about advisors. Some point in time, it is about the financiers. But then, all in all, small or large, the deal is about the investee and the investor. And then you need to create what we call as a win-win situation, else there is no deal. And when there is no deal, it's a bad deal for everyone. And I've always believed that a good deal is a deal which closes. A good deal is a deal which closes on equitable terms. A good deal is a deal which where the agreement that you enter into is never open for enforcement, but is open to see what avenues it provides you from a growth standpoint. And that's my overall emphasis in terms of what this whole investment agreement is all about, is to create and is to see how we can create a win-win situation in the whole process. So let's look at what are the steps that you see on the investment side, and then you have the following things that appear on your screen, which pertain to first, of course, the evaluation. And if that evaluation turns out to be true, then you start with uh, the preliminary negotiations, the term sheet, the due diligence, the definitive agreement, the closing, and then the very important aspect of managing that relationship, getting that investment, and getting investment on the investor on the board is just the start of the relationship that you have to invest in, called investor relations. Very critical function leading to a successful exit. So there are steps, and you could at times curtail some of this or fast track one of this, but this is how the transactions generally flow, where the evaluation would lead to a preliminary negotiation with the investee company, leading to a term sheet which documents uh, contours of the deal, which leads to a due diligence. Due diligence is trying to find out on the legal side, finance side, business side, operation side, what is this business all about in depth, because you are now going to become part of the investee company, and then you are going to live together for a long period of time. Definitive documentation is also something which is a critical factor, which is in relation to what is the term sheet moving into a binding agreement. That's what definitive documentation do, leading to closing, which means money in the bank, and as the investee company, you issuing shares or any instrument as such to the investor. That's the closing, where he pays money and you, in return, provide him with the uh, uh, a share certificate or a securities certificate as such. And then, as I said, investor relations start. And after the investment has matured, at times you have an exit. Exit could be by way of an IPO or by way of an M&A and what have you. That's something that you would essentially look at. The stakeholders in the overall transaction. You have directors, you have employees, what we call as a key managerial position people, creditors, debtors, customers, and the legal and financial advisor. There could be an investment banker as well, who is an important constituent of the overall transaction. That would be something which would be critical in terms of looking at. These are all players who come together to make sure that the transaction happens in one way or the other. Let's look at structuring consideration. How do you actually get a new investor onto your cap table, into your company? There are two ways to look at it. One way is to say it's a primary issuance, which means that the money comes into the company. The second is in relation to what we call as a secondary sale. Secondary sale would mean that the existing shareholders are selling to a non-existing shareholder, which is where the money doesn't come into the pockets of the company, but goes in the pockets of the shareholder because he is selling the equity or preference or any of the securities. That's the difference between when we call as a primary and when we call as a secondary. Just to take 2 minutes in terms of what does that mean? It means that there are further issue of shares where existing shareholders can get the right to subscribe called rights issue, or the new shareholders get the right to subscribe called preferential allotment. Both of this constitute further issue of shares. New shares get created in this process. Or you could do bonus share, which is nothing else but capitalizing the free reserves and moving them into the share cap table. This is done when your reserves have ballooned to a large extent, where your per share price, especially true for public companies, is moving into a direction which is difficult for a small investor to look at. And that's something that the bonus issue does. Private placement, ESOP, sweat equity are other nuances in terms of getting the primary issue, which is by subscribing to the fresh shares, and in return, you get the share certificate associated with it. Or if the shares are under electronic format called DMAT, then you get those shares in your DMAT account. Many of you would be investing into the stock market, and you would have demat account, and that's what most of the people are doing at this point in time. The secondary is very simple, where the existing shareholders are effectively selling their stake and inviting others to essentially get on to the overall process. The secondary shareholders are going to be important in the rather the secondary investment is an important mechanism for the existing shareholders to create and monetize their investment and create liquidity for them. That is something that you call as a secondary investment. And there is a combination investment where in the same transaction, you have a primary investment and you also have a secondary investment. Both together would constitute a combination. In the same transaction, there's new money coming in and the existing shareholders selling. Even in the IPO, today, this week we will have about 5 or 6 IPOs. If you look at those IPOs, you will find that there are new shares going to be issued, primary shares, and there are secondary offered for sale, as they call that, OFS. That's happening both in tandem, called combination investment. So that's something that you look at in that way. When you structure the transaction, any investor transaction with multiple investors, you're looking at creating a shareholder agreement, share subscription agreement, where the rights of the existing investors and incoming investors get bifurcated. And then you have to balance amongst the founders, investors who have come early, and the investors who are coming in now. How do you regroup them and create what I call as a mechanism where every one, which is the founder, the shareholder, earlier shareholder, new shareholder, rights are clearly defined and they have enough protection amongst each other. That's an important one. And that is where the shareholder agreement comes into play. And we're going to talk a little bit about what does that shareholder agreement exactly mean and what are those terms of that investment agreement that we all should be aware of. And that is the reason why I wanted to give you a complete background, including the process and the mechanisms of raising capital and getting a liquidity between the existing shareholders, so that you have a background on which the document is negotiated. So that background is critical, and the process on the negotiating these clauses, what we call as an anatomy of the investment agreement, is then well understood, appreciated, and well regarded in that way. Let's look at key legal clauses. Let me stop and see if there are any questions in the chat box.
Sridhar, Vivek, right now there are none.
Okay,
So
fine.
I'll
All
alert you
right.
when there are any.
Okay. Mugdha, is this space all right?
Yeah, this seems okay.
Perfect. Thank you. Uh, let's talk about the key clauses in the agreement. I'm going to spend, next 15 minutes talking about this. Let's look at how the investment comes. I mentioned to you a while back that you have a primary, you have a secondary, or you have a combination. There's another nuance to it where not all money will come at one go, which means that the money will come in tranches. The investor says that, why do you need this whole money when you're not going to spend? So let's assume that there is a 10 mil US dollars investment expected, and the company doesn't have a plan to spend that 10 mil, what we call as an object of the issue. And you are then looking at a situation where you want to make sure that that money is well spent at the time it is required to. While there is a commitment to do 10 mil investment, it will come in different tranches. Many a times, after the first tranche, the investor says that show me the performance and demonstrate that you are worthy enough of me putting in the additional sum of money. So what is happening here is that you are essentially looking at a situation where the money doesn't come at one go, but comes in tranches, comes either at the gap of a certain time frame, which is what we call as a time bound investment, or milestone bound investment. And milestone bound would mean that you have to cross a certain threshold, where that threshold could be of a particular revenue number, particular user number, particular profit number, or combination of any of these things. And you could be creative in terms of what your business actually has to perform and what have you indicated to the investors that will come back to you. And therefore, while you actually provide any sort of forward guidance to the investors, remember that it can come and hound you at a later point in time, and therefore be as rational as you can. Then it will provide you with a better outcome. The second important thing is reps and warranty. Remember, while the investor does the diligence is only a paper diligence and done in a crunch timeline. When you go to buy a house or a property, if you remember, you ask for one particular document, which is called as a title document, and say that, you know what, until the title is clean to me, my ownership will not be clean, and therefore I insist that we need to have a, a, a clean title report. And that's exactly how an investor is looking at, saying that, hey, you know what, you're saying that I'm a good company to invest. I'm coming basis your A, B, C, D, E, F, G, H representation and warranties, which means that you are making a representation that the statement that I'm making is true, subject to caveats and subject to any kind of disclaimers that you have already provided to the investors. But that in legal parlance means that if there is a misrepresentation, or if there is a sort of a breach of that warranty, then the contract is voidable at the instance of the person who is at the receiving end. Which means that if I'm an investor and you tell me, hey Vivek, you know what, this is all clean company, there are no litigations, all is clean, and on that basis I make my investment, and it turns out that there was actually a litigation which was hidden in the back, and all the hell will lose break in terms of, if that was hiding, that's a misrepresentation, and then law allows me to walk out of that deal at my option. If I give a chance to correct that error, that's okay. But then the option to terminate, void the contract, make it null and void, as we call that, is something in the hands of those who is suffering on account of wrongful reps and warranties being given, which is a very important talk and topic. The third is about the indemnity. Remember that the investor is looking at investing in the company but doesn't want any liability. Let's take liability and indemnity as a bucket. He doesn't want any liability apart from what you have disclosed, saying that, hey, you know what, there are two litigations, and one litigation could, drain our resources. The second is a criminal charge, so something can happen to me. Now, obviously, the investor is looking at answer to that, saying that what is the probability that this will happen, or what is the probability of this will not happen. Both those cases, they look at how you deal with this situation, and you come to a common ground in terms of what liability is acceptable, and therefore what kind of indemnity would the investor look out for from the investee company to make sure that the risk to a certain extent is mitigated. That's very, very critical in any of these transactions, and these are highly negotiated clauses. Remember that the situation makes dramatic change when you have cross-border uh, investments coming in. There are regulatory hurdles for sure, but those regulatory hurdles, at least but these man-made hurdles can really get into a deal situation as such. And therefore, as you get into a conversation looking at what is the liability associated with this investment, and therefore how do you seek the indemnity, which is prior to the investor coming in, those become very important and critical. Non-compete, the investor is very clear that he does not want the founders and the key management people to compete against the business in which they are investing. Please understand and appreciate that the investor is taking his money on you as the co-founder or the founder or the senior management. He is looking at a situation where there should not be any egg on the face with someone leaving and opening the shop in the face of the company. If the person is disgruntled, he could go at distance to make sure that all the issues come to the fore, and then they essentially take advantage of the situation. And therefore, the investor, being wary of all this, would insist that we would want a non-compete, not just with the promoters, but also with the key managerial people who they have exposed to the investor to look at how this non-compete and non-solicit both. Non-compete is to stop a person from creating something competing. Non-solicit is both on the customer side and on the vendor side. Remember that the investor is putting in money, looking at the founder, looking at founder's pedigree, looking at the business, but it's all looking in future. It is not something that has actually uh, got done uh, effectively, where you create a competing product or service, and then there is a completely situation that you're looking at. You don't want your people to go, you don't want your customers to go, and therefore the investor would insist on some of these clauses present not just in the shareholder agreement, but also on the rewritten employment contract with the uh, with the uh, with the investor. That's a very, very important aspect. The next point is in relation to founder lock-in. What does that mean? Founder lock-in means that the investors are investing looking at the founders, and the founders are not in a position to sort of uh, go outside of the company. The rule is that the captain of the ship jumps the ship last, right? That's the rule. That's the golden rule. And the investors also believe that they can be co-terminus, jumping from the ship together with the founders, but the founders can't jump the ship while the investors are within the ship. So the golden rule is that the founders have a certain lock-in, and then post the lock-in, the investor says that, hey, you know what? First I will go, and then you can either tag along with me or you follow me. Okay. So, the investor would always want to get out before the founders are, because remember, the investor is putting in money, whereas the founders are putting in a small amount of money, maybe, but more importantly, a full time and sweat that goes on building what we are essentially building. The next point is on the veto matters. Veto matters would mean that investors would want certain matters which are critical, like change in the operating business plan, like appointment of directors, like change in the articles and memorandum, change in the annual business plan, and so on and so forth, that you do not want to be in a situation where you didn't want to say yes, but because the other people come together, you sort of align yourself with them. The point I'm making is that the veto matters are critical in these deals because the investor in most cases is minority as compared to the majority shareholders, and therefore they would want to protect their right by asking for veto matter rights, or in other words, investor, what is that word? Affirmative veto matters, AVMs, and those effectively, to repeat, mean that unless the investor says yes, it won't happen. Or if the investor says no, it will stay as no. And that's an important, what we call, and a hard hitting right that the investors would seek. Many a times in a private equity deals, when the founder of the company is in minority, then at that point in time, the founder actually would seek veto matters, and they would essentially seek the veto matters in such a way that you would want to look at uh, um, their protection, like we saw the protection that's flowing to investor when they are in minority. So effectively, those who are in minority need veto rights, and that's something that is embedded in the transaction documents. Breakup fees, that's something, that concept is coming in where you have multiple options, and the investor says, and one is, it cuts both ways. The company has multiple options to choose from, or the investor has multiple options to choose from where to invest. In both cases, if it is not deliberate, of course, the breakup fee doesn't apply. But if it is deliberate, just to say that, what, I'm getting a better deal, I'll go and, latch onto it. That's something which is what we call as a breakup deal, that, everything was all right. I was willing to continue with my contract. But if you did not want it, or if you break it, then I have all the reason to believe that, you could potentially deal with that in that manner. So that breakup fee concept is starting to come in the agreements, and we are seeing, as the momentum increases, you will find that the breakup fees come to hound you. The other one is jurisdiction and the dispute resolution. This is another important one. Under which jurisdiction? Think about it. An investor is sitting in the US. You are in India. There is a cross-border investment taking place, what we call as an FDI, into India. At that point in time, which law will apply? And if there is a dispute, will you solve it in court or arbitration or mediation or combination of these things, is an important consideration. I kept it at last to demonstrate that while this is the last point, and by the time you come from the first to last, you're exhausted. But then playing on the home pitch condition is far better as compared to playing on an alien pitch and on an alien land. And therefore, it's important to understand as to what is the jurisdiction and the dispute resolution mechanism that you are agreeing to. One myth that stands, that all arbitrations are good and courts are bad. It all depends on which side of the table you are in. More importantly, what is it that you are essentially looking at, on which side of, are you from a probability standpoint, thinking that you will sue or you will get sued? Depending on that, you would want to create a dispute resolution mechanism. Remember that the arbitration is a costly affair. It might seem that it is a quick process, but not every time it is. And it could be a cost prohibitive thing. So blindly don't sign up for arbitration, or a court unless you have understood the nuances. And then which law will apply? Will India law will apply? Singapore law will apply? Or which law will apply? Becomes also very important and critical to understand as such. Any
So,
questions?
yeah, Vivek, there are two questions in the chat box right now. So, Ashish wants to know, is there a lock in for PE or VC or HNI? And if yes, how it is decided? And what is the level of regulator intervention during the entire process? Is the overall process similar for SMEs and main board listers?
Right. So let me answer that. That's a very good question, Ashish. Thank you for that. Is there a lock-in for private equity players, venture capital? Yes, you should insist if you are seeking investment. Generally, the traditional situation is the industry standard is that they don't accept any lock-in. They want their shares to be fully transferable without any situation. But at a certain point of a company's overall growth phase, you could insist that we don't want any churn, and barring certain things, which is what we call as fraud or the usual suspect uh, situations, barring that, the shares cannot be transferred, right? That's an important consideration to keep in mind where you are, wanting the private equity to also sign up for a lock-in as they expect the founders to do it. But then at that point in time, you have to be a shoulder to shoulder. If you are early stage or of course a growth oriented company but early stage, then that could become a challenge. What is the level of regulatory intervention during the entire process? So if it's a private investor investing into a private company, there is a very limited intervention. Today, most of the transactions which are overseas as well, domestic transactions, you only have to deal with post the transaction compliances relating to filing of forms and informing the stock exchanges or the Ministry of Corporate Affairs. It's a very minimal regulatory intervention. But if it is a cross-border one, then foreign exchange comes into play and you have to comply with the foreign exchange rules and regulations. I must say that even the foreign exchange rules and regulations have got liberalized over a long period of time now, almost 2 decades. And therefore, there's a very good understanding overall in terms of what is expected of that law and how do you actually translate that law into a reality. So, to answer your question, the regulatory intervention is limited, except when you are going for a IPO, like you asked as to is the overall process similar for SME? The IPO process is very, very different. The IPO process is, regulated by SEBI guidelines, ICBR as we call them, and those guidelines are onerous and they allow only right set of companies to come on the exchange because remember, public money is involved, and wherever there's public money involved, people are conscious and cautious of the fact that right mechanisms, right checks and balances are applied. And therefore, for the SME and main board listers, that is listing on the stock exchange, is a elaborate process. And what I explained to you was outside of the IPO process because that is a topic in itself. Uh, Anti-dilution clause, Kasturi is asking this question. Anti-dilution clause would mean that the investors, if they have invested at a certain value, and the next investment comes at a value less than the value at which the investor has come in. Assume that the investor came in at $10 million, pre-money valuation. They added 2 million, so 12 million happened as the total post-money valuation. Next time, company goes and gets a valuation of only $8 million, then the investor says that make good that difference between 8 and 10 or 8 and 12, depending on how you write the agreement, and make sure that you are giving me additional shares in such a way that my total value of the shares in the company is not diluted, and therefore it is called as anti-dilution. So the investor is making sure that they get more shares at no cost, which effectively means that you are essentially getting in more money in the or rather you are getting more shares for no money in the bank. So which is a hard hitting for company, but from an investor standpoint, that is an important element to make sure that they don't get diluted because of the lower valuation in the next round of funding. Bipin Deshpande is asking a question: do investors determine direction of the business? If yes, at what level of investment? That's a great question. And you are clearly looking at a situation where the investors do determine the direction of the business. You therefore have to select your investors well. And this evaluation process that we had spoken about uh, some time back, therefore, is an important one. And the evaluation is not just by the investor of the investee company, but it is also of the investee company of the investor, to make sure that there is a marriage of equals, and that equal thought process is an important thing. When you look at that, you are looking at a situation where, uh, okay, where is that question gone? Let me see. Okay, yeah. Uh, yeah. So the investors can influence the business in a positive manner. And at times, if there are differences and if you don't manage this investor relation well, it could turn out to be a difficult task. So what is required? The communication has to be immaculate. And what is that communication? The communication is about informing anything good or bad or ugly that is happening, following through your obligation under the agreements, making sure that your business plan is well understood by the investors and you give timely, and not after the incident has happened. You ought to give a very timely feedback to the investors, saying that, you know what, this is what is happening, and this is how you would want me to look at. And at many times they are part of the board, they may not be part of the board, but they are extremely supportive when there is a proper communication. The business may fail, but the communication should not. The communication is the key in terms of managing the relationship. Doesn't mean that only communicating gives them comfort. Communication with the results will obviously give them a lot of comfort in that way. Dr. Premnath requested me to talk about founder vesting and liquidation preference. Thank you for nudging me to talk about it right away. In this, what we are talking about is that uh, there are there are certain rights in the shareholder agreement, which is what we call as liquidation preference, which means that before anyone else, the investor has a preference to take money off the table, what he has invested, and then he can also participate in the growth of the company. Now, these are two situations that you need to look at, what we call as a double dip and a single dip. Think about a situation where the investor has made an investment at a valuation of 10 mil again, with 2 mil invested, the total valuation is 12 mil. There is an offer that comes for the company to be bought back at a value of, say, $20 million. At that point in time, one clause could say that the founders, rather the investors, have a liquidation preference, which means that they can take money off the table before anyone else. They can dip into the 10 million that is invested, and then the rest of the 10 mil is distributed amongst the either all the shareholders or shareholders excluding the investors, depending on how you negotiate. That liquidation preference will determine whether you are giving a disproportionate right to the investor, and therefore whether you as a founder and the existing shareholders will make money or not make money. A just clause is where when you are in money, which means that you are giving returns more than what the expectation is, or more than the value at which the investor expects, at that point in time there is no liquidation preference and everyone is pro rata. So if I invested 10 rupees and got 20% equity, and if the valuation at which I invested was overall 100 rupees, and if the next time there is a liquidity event and the valuation is more than 100 rupees, then everyone is pro rata because everyone is in money, including the investors. So this clause is very critical for you to look at. The second thing is on the founder vesting. Many times investors are insisting that all the shares that have gotten to the founders, and especially in the Indian context, it works little differently. But let me explain the concept. The regulatory angle, let's keep it for some other day. We have limited time on hand. The founders are being told by investors that earn your equity. It's not entitlement, which means that perform and then get back what is your equity, which is what is called as a founder vesting. In India, the way it's implemented is little different, but as a concept, what investors are saying is that, you know what, we are happy to give you 40% of the company, but you have to earn that 40%, and you are not entitled to 40% just because you are the founders. And they will vest in you provided you complete certain milestones. Those milestones could be time based, or it could be revenue based, it could be profit based, it could be user based, it could be combination of any of these things. But founders vesting is an important way in which there is skin in the game, and there is a validation of the business, is how the investors would look at in that way. Bipin Deshpande asked a question: is there any advantage in getting an investment from any particular country, or a disadvantage if is of a particular country? Now, obviously there are certain embargoes on certain countries, like Libya, Iran, Ukraine, and bunch of those. And obviously you would want to take a deep breath and say, hey, you know what, there is a hurdle taking from these countries. Barring that, there is no regulatory hurdle as such. India is open to do business with most of the countries in the world, so there's no issue. Is there an advantage of getting an investment from any particular country? Obviously, if you're a product company and you are headquartered in the US, Singapore, and some of those jurisdictions where it's a better outcome vis-a-vis the IP infringement and things like that, obviously it reflects in the valuation asset. But having said that, just because you are in a particular geography, you are not entitled for a super valuation. Your business has to speak for it. It's a much more deeper question to answer, and I'm happy to have offline conversations about it. But regulatory wise, there are only few countries where if they are on the blacklist, the rest of the countries would be okay to take investments from. And as a golden rule, a product company gets better value where the IP enforcement is far stricter and far more effective as compared to some of the other countries as such. All right, okay. Do investors determine direction of the business? I answered that. Vikas also has some point to make. Anti-dilution. For example, if there's a third round at 12 mil, is the share structure readjusted or the investor stays newly allocated? Yeah. So, Lakshya, what happens is the value of the investment by the investor would not drop. So if he has invested 10 mil and has gotten, say, 20%, and the next investment is gotten at a discount to 10 mil, 8 mil, then 20% difference of this 8 and 10 to make the investor go back to his value of 10 mil, those number of shares will get added to him at no cost, which means that he will be on the same position in terms of money, but increased number of shares as such. Um, Kshitij is asking a question: for every new SHA signed, does it apply to the older investors too? Meaning, do their rights assigned through older SHA gets revoked? Thank you, Kshitij, for asking this. The way it works is, and the better way is to have only one agreement. You actually terminate the first and rewrite the other. That's the best way so that you're not looking at two documents at any given point in time. It's just one document. What rights override the old investors? What right override the new investor? All is a matter of debate. There's nothing is cast in stone. Think about it. If it's a friends and family round who's putting in say 2 crore and you do exceedingly well and go for a 10 mil investment, the 10 mil investor is not going to agree to be subservient to a 200k investor, because that amount is very different, even though the risk taken was large and it could have been zero of 200k. But the way it works is that what overrides what rights will continue, what rights will get diluted, all that is a good question to actually think through and ask yourself. So the point I'm trying to say is that every time there's a new investor, uh, should mean that the earlier agreement is either terminated, or the new agreement is drawn in such a way that there are no overlaps, and you create a bridge in terms of how you look at uh, the 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 rights of one class of shareholders in Series A versus class of shareholders in Series B. So it at times becomes a daunting task, and clarity around that early on as you are negotiating the overall contours of the deal are very critical. You can't take for your existing shareholders for granted. Many a times their agreement will have no objection or a consent situation to onboard a new investor. And that's a good time to have a conversation in terms of what will work and what will not work. Uh, uh, Dr. Premnath is requesting me to talk about SAFE, CCD, CCPS, equity as such. Uh, let me talk about it. This is important. Thank you, Dr. Premnath, for bringing this again. All that you want is to have a set of standard things that can help raise money in a quicker manner. There have been a lot of attempts in India as well to get a certain set of rights understood by a certain set of investors. So the friends and family, or sort of a non-institutional round, many a times, and at times some institutional round, also goes through a safe note. And in India, we call that as iSafe, India Safe Note, which effectively talks about a convertible instrument where the amount of money invested converts into a certain number of shares upon happening or non-happening of a certain event or a time period, against which the company will issue equity, preference, or any of those shares, which can effectively be at a discount to the value at which the current round of investment is being taken. Assume that you raised $1 million under safe note, iSafe note, and then you are looking at what is, and that's a convertible note essentially, uh, similar to a CCD or a CCPS in that way, where it will convert compulsorily into a equity share at on happening or a non-happening of an event. And most of the time, that happening or a non-happening of an event is a next round of funding. So assume that you have a next round of funding at 10 mil value. So the person who's invested 1 mil would have negotiated that he will convert himself into equity shares at a discount to the value at which the next round of funding is happening, which means that he'll say, hey, you know what? I'm not investing at 10 mil, or rather, I'm not converting at 10 mil because I don't get anything benefit of taking the risk. I'll invest at 20% discount, which means that I'm still in money, but I'm converting at 8 mil. So I have a return of 20%. That's how some of these, convertible instruments are made. I know we are running short of time and therefore I'm rushing to a certain extent, but these are very important instruments to look at beyond a cookie cutter, what we call as equity or preference shares. There are a lot of nuances and a lot of structures that you can use to make sure that there is no fight of the valuation as you enter into a conversation with the investor, and that conversation related to the valuation happens when the real investment, which is an institutional round, comes. And at that point in time, there is a science behind how you value a particular company. The company has matured as well, and you are then looking at a situation where you are able to determine scientifically what is the value of the company, and therefore those who are early investors convert themselves into equity or a related instrument in such a way where there is a discount to the real institutional round of funding, making it good for everyone. Um, Mukta, I'm not too sure if I missed any of the questions, but if I have
No, I
you,
think you have yeah, covered it up till now. Yeah.
all right, okay. Uh, can I have 5 more minutes,
Yeah, I think if
Mukta?
you're okay, you should actually, because I
All
think
right. I mean,
yeah.
look, there's so much to talk about this. This is a fascinating topic. We all, must do many such sessions because that's how everyone will learn in terms of looking at. What I'm trying to, look at, provide you as a guidance is how does an investor look at and how does a promoter look at when there is an investment coming in, and what are the risks associated with these investments, and how do you mitigate the risk? If you remember, one of the points that I made is about sharing of this risk, and how should investor protect his risk, and how should promoter protect his risk is an important element of negotiation and balancing each other's interests. Remember that investor is investing obviously in the business, but he at an early stage is investing in the person and the founders essentially, and he is taking a leap of faith, and therefore he has to rely on the reps and warranty. Anything which is said has to be a gospel truth, and if it turns out to not to be, which is what we said is a misrepresentation, will have its own consequences. The other thing is that when the investors are in minority, they ought to protect themselves in terms of certain things that the law doesn't allow, and therefore they do it through the agreement where the operating clauses go and sit in the articles of association of the company. So there are, ways and means in terms of that risk understood is mitigated through certain measures, like I have mentioned, and so does the promoter or the company and the founders do that when they are in minority. How do they look at it when they are in majority but the investor has few rights? How does he look at it? So there are various ways in which both parties are trying to mitigate their risk, and that objective has to be very clear in terms of what risk they assume, what risk they are willing to consider, and what risk they are unwilling to consider. That's an important one to look at. Uh, there are incentives that go in making sure that the management team, while there is an investment that comes, is adequately protected. The investors are very clear that they would want not just the founders but the next level team to also benefit, and they are the people who are going to make it or not make it, and therefore they would provide a fair bit of elaborate what I call as plans, which are incentive plans, ESOPs, stock appreciation rights, sweat equity, and whatnot, to make sure that everyone feels motivated in that. Uh, we spoke about some of these things on affirmative veto, anti-dilution, All these rights are critical and documented in the agreement in relation to transfer. Transfer is a very critical thing. Remember that when the investor has shares, the only way he is able to make money is when he transfers those shares. And therefore, all the provisions relating to who has the right to buy, who has the right to sell, at what price, when does he have the right to sell, that is after the lock-in period, what are the tag-along rights, what are the drag-along rights, how does the investor, rather, how does the promoter be in a position to sell, how much can he sell. We also spoke about the investors wanting to go out before the founders go out. All those are part of the rights granted to the shareholders under the shareholder agreement that, as I said, will go and send in the articles of association. Restrictions on the shareholders, we spoke about it on the non-compete, non-solicit, lock-in period and things like that. They are all part of the documentation. We spoke about the veto rights. We spoke about, yeah, one more thing is that the investors like to have the ability, not that every time they would do it, but they would like to have an ability and a right to put one person on the board of the company to protect their rights, or observer seat, which is non-fiduciary, but gives them a complete insight on what is happening at the board level, and they can influence certain decisions based on their experience, and to make sure that everyone is all above board in that process. So those governance rights are also part of the investor agreement and investment agreements as such. The employment and operational activities of the founders, another important aspect. Don't neglect that. When the employment agreement comes from the investor, make sure that that's all well read through. We have seen a lot of cases where there has been a spat between the investor and the founders, housing.com, Snapdeal, bunch of those, and where it's a value dilution. So how do you actually make sure that what rights investors have to terminate the founders, all of that becomes very critical as such. Uh, my last slide is in relation to the exit strategies. Um uh, and let's look at those. We spoke about the IPOs in brief. Uh, IPO is, if you look at the number of companies that go IPO, uh, vis-a-vis the companies who sell and take an exit, the ratio could be 1 to 100. Not many companies will go and do an IPO, but that's one of the exit strategies that the document will have clearly. The strategic sale to third party, strategic sale to the founders, the buyback, all this is actually the practical way of the investor getting an exit. Like I said, the investors go out first, then the founders, if at all. But most of the time, the IPO or the sale to third party, sale to promoter, buyback options, all that, etc., is something that becomes a critical exit situation. Last in the hierarchy is the drag along ride. The drag along ride is something which is a draconian one. If all rights fail, then the investors would want to drag the founders and say, you know what, we want liquidity. And if not anything else, then we will have the ability to drag you along with us if we find a buyer and then get an exit. So those are some things which are, exit strategies. I'll stop here. I mean, the tips and traps are something I'll keep here. Let me see if there is any more questions that I can answer. I know I've taken 10 more minutes. Appreciate your patient hearing. Mukta, any questions?
Yeah. Before we take further questions, let me remind everyone the feedback link is in the chat box. So before you leave the session, you please give the feedback so that we can improve along the series. Just let me check. Yeah. Which types of investors have a say in the valuation determination at different stages?
Uh, you know, all investors can have a say in the valuation. It all depends on what is negotiated by the founders. It all depends on what rights that they have, and at to what extent they will have a say. And is that a veto right? I don't like to see a veto right to investors on the next round of funding. We have seen so many examples where the clients have got into a situation where there was they were they they had to succumb to what the investors were talking about, and therefore you have to weigh the risk of not being able to raise the next round of funding uh, if the investor does not play along with you. And the reasons could be multiple. Many times they are business, and many times there could be non-business. Business you can address, non-business are difficult to address. So one has to be very careful in terms of what right do you give for a further round of funding, which is also in a way determining the valuation of the company. Uh, the golden could be that once I have given you an anti-dilution right, which means that I can't go below the value at which you invested, and if I go, then I have to issue you additional shares to continue to keep you at that level. That's a good enough right for someone. And all the other way of looking at it is to say, hey, you know what? We will not deal with A, B, C investors. There could be a reason for that. You document that particular thing, which is fine. But giving a wholesome right where the investors have a complete control on the next round could at times be detrimental, though it's hard to negotiate in the Indian conditions, I must say.
Yeah.
Um,
I think there are no more questions in the chat. Dr. Premnath, do you have anything to say?
Yeah. Hi, Vivek.
Hi, Shruti.
Shruti. Yeah, hi. I think you have covered a lot of ground and pretty much in as simpler terms as possible, because I know it's very difficult to explain it in a simpler way, because all these legal language is very challenging to convert in a common person's language. But it was very nice, and I don't have any question because I think most of them have asked the questions that they have in mind. Because but I just wanted to thank you for putting it so well.
Yeah, just a last bit, Shruti, and for
Mm.
everyone is that, please do understand that good document is not a substitute for a bad partner. So, the first the partner and then follows the document. Document can
That's
only
correct.
do so much. And also remember that, you don't want to make a lawyer like me rich. You ought to do your homework. The lawyers can only help make sure that, the broader points are all taken care, but I think the diligence is an important one. And I'm sure, the more such conversations happen, you will understand that everything is negotiable as the investors come and say, hey, this is not negotiable. You need to understand as to why is he saying so. There has to be some reason, and you need a better explanation. If there is, I heard today on a lunch table while we were talking to one of the clients that the guy is telling us that this is how we work. I mean, and he's a large investor. And I said, think about whether that's the right investment partner for you, because I always have understood that everything is negotiable in a business as such. Yeah.
Um, Vivek, sorry, I had to take a quick call in between, but thank you so much. I heard most of your talk except for the ending. But thank you for covering a lot of ground. But I'm sure there'll be more opportunities to dig deeper into perhaps one instrument or the other, right? And then we can get a chance to hear you again.
Sure, no, happy to do that. And this is my email for the audience. If you have questions, do send that to me. We have a good team. They can answer, I can answer, and happy to step in anytime you want me to deeper conversation on one of the topic amongst many that we spoke today.
Sure. Thank you. Thanks a lot.
Thank you,
Over
sir.
to you, Mugdha.
Yeah, thank you, Vivek. Shruti was pointing out really broad topic and covered very well. Of course, thank you for also giving the extra time that you had to take for covering the entire session. So, with this, let me again remind everyone the feedback link is in the chat box, and please do give your feedback before you quit the session. Thank you once again, Vivek, and we will meet everyone for the next talk in this series, which is coming up on the second Tuesday of February, which is 13th of February at 4 o'clock. So, see you all.
Thank you. Bye for now.
Thank
Thank
you.
you.
Bye.